What's going on, chat? Cheers. HBO Matt, you know how to get a hold of me, right? Get a hold of me. All right, let me y'all can't hear the audio on the sound. Okay, let me look real quick. This should fix it. Back it up a little bit. Still kind of looking into this case. There was an oral argument on it, so I'm not going to know much on it other than the guy was arrested, and oral argument was interesting. Apparently, they dislocated his shoulder, and then oral argument, which I can play here in a bit, described the arrest as a, I guess, nice or standard arrest. So I was curious. I want to look at the body camera to see what the hell is a standard arrest. So I figured if I was going to watch it, just, open it up to you all as well. So I don't really know what to expect here, but I'm going to play it. Tell me if you hear the volume. All right. Y'all should hear it now.
You got anything on you?
No, hell no. Hold up.
Behind your back.
Man, what's going on?
You already know what's going
Oh,
on. That's why you calling your people. That's why you calling. Let go your phone, man.
Hold up, man, my arm, bro. What is going on, man?
Good deal.
You already know
Twist your wrist,
on.
bro. I don't know what's going on, bro.
Twist your wrist.
Look, I'm boss man.
Boy, HBO Matt,
bro.
you know why,
You
right?
ain't
Because
doing
at the same time they were doing the meeting,
Where you going? You got
they
anything
were
on you,
also
bro?
I
in
ain't got
court.
shit on me, bro. The fuck?
Why are your pants all wet?
Man, I just came from a trail ride.
Oh, stop.
Look, I just came from a trail ride.
Where's your car?
My people in them just dropped me off. My people in them just dropped me off, man.
Where's your ID at?
In my pocket, my right pocket.
Okay, why are you yelling at me?
Because I'm trying to see what's going on. It's 2 o'clock in the morning. Y'all run up on me like that. I don't know what's going on.
Get in here.
The fuck? Hold up, my arm, bro. Hold up, my arm. My arm.
Hey, what's going on, Brandon?
Get
I'm
in
not
there.
going to bro for boss man. My arm, I'm telling you.
What do you want me to do?
You got them too tight. Unloosen a little bit.
How did I got him too tight?
I'm not running nowhere, bro. Unloosen a little bit of something. That
Well, if you
motherfucker
wouldn't
too
have
tight.
it, so...
That motherfucker too tight. Ah, shit.
You wouldn't have been fighting in that one. Lean forward.
Fight nothing.
Lean forward.
Ah,
Lean
shit.
forward. Keep going. Look,
All right.
I'm going to loosen this one. I'm going to put 2 on you. But you better not move.
Cool. I'm not going.
It ain't. Don't
Boss man,
move.
I'm not going.
All right.
So apparently the argument here is, let me change it up to the oral argument. The argument here that drew me onto this case was apparently it was this specific instance where this individual's shoulder, I guess, was dislocated. The officers got qualified immunity, went up on appeal. The appeal got turned over pretty quick. I'm going to play it. You should hear sound right away. If not, let me know.
Get started. It is case number 24-20426, Hayes v. City of Houston. And I am not going to attempt to pronounce your name, but you can introduce yourself when you come up. Yeah, please do.
Can you all hear that okay?
Say one more time.
Hauthausen.
Okay, Hauthausen.
Yes, sir.
Okay.
Good morning. May it please the court. We would ask this court to reverse the dismissal of appellant's excessive force claims against Officer Doss and Officer
Rotorhead
Barnes
vet.
at police.
How you doing?
Remand this case to the district court. My name is Alexander Hauthausen, and I am here on behalf of my client, Jonathan Hayes.
So we're hearing the
appellant in this
plaintiff's
case before the
counsel
court.
right now.
We are here
the
today
guy
to
that
ask
got
this court
arrested.
to help us in holding law enforcement accountable at a time in this country when accountability is what we need most. When a person
Please, don't give us a political speech.
Oh, I apologize.
Tell us what.
So, if you all know or have been through the appeal process, you save all the political stuff, the fancy stuff, really for juries or the public, not so much for judges, especially at the appellate level, right? They all have their dockets, and they're not going to decide things based on passion. They're going to do it purely based on the facts and the law. However that shakes out. So just kind of keep that in mind. So obviously, to get ridiculed in the first, I'm not even in the first minute, they're already trying to tell counsel like, hey, knock it off. So just keep that in mind in case, it's not about selling the story to the judges. At that point, it's about selling the facts as applied to the law to the judge. The story and the passion, that's for everyone else.
What accountability is needed more at this time in our country? Just argue your case.
Yes, Your Honor. When a person acts under color of law, their actions must be examined, and if their conduct harms or hurts a citizen.
Okay, before I go on, you all saw the arrest, right? I assume you all just saw the arrest. If not, we can go back and watch it. I guess I'm curious, how do you all view the arrest? Did you think that there was an issue with the arrest? Do we need to go back and watch it before we kind of feel out how the judges are going to attack this? I assume they're going to attack it, right? I'll just tell you, based on what I saw, they denied the appeal. They didn't offer much of an opinion. It was literally a paragraph. So for those of you who saw the arrest, did you see any issues with it? All right. Okay, miss it. What I'll do is I will come back here and we'll go back and play it. I just watched it a couple of minutes ago. Okay, so we're going to watch this arrest here. And then I really want your opinion, like objective, right? Like if you were sitting on the bench, because we've seen bad arrests, right? I know I've seen bad arrests. I know if you're watching this, you have seen bad arrests. So give me your thoughts on this one.
You got anything on you?
No, hell no. Hold up.
Behind your back.
Man, what's going on?
You already know what's going
Oh,
on.
no,
That's why you calling the people. That's why you calling. Let go of your
phone, man. Hold up, leave my arm, bro. What is going on, man?
You already know
Twist your wrist, bro. I don't know what's going on, bro.
Twist your wrist.
Look, if I'm boss man, you gonna hurt my arm, bro.
You don't want fighting it, dude.
I ain't doing nothing.
Where you going? You got anything on you, bro?
No, I ain't got shit on me, bro. The fuck?
Why are your pants all wet?
Man, I just came from a trail ride.
Oh, stop.
Look, I just came from a trail ride.
Where's your car?
My people in them just dropped me off. My people in them just dropped me off, man.
Where's your ID at?
In my pocket, my right pocket.
Okay, why are you yelling at me?
Because I'm trying to see what's going on. It's 2 o'clock in the morning. Y'all run on me like that. I don't know what's going on.
Get in here.
The fuck? Hold up, my arm, bro. Hold up, my arm. Hold up, my arm. I'm not going to bro for boss man. My arm, I'm telling you.
What do you want me to do?
You got them too tight. Unloosen a little bit.
How did I got them too tight?
I'm not running nowhere, bro. Unloosen a little bit of something. That motherfucker too tight. That motherfucker too tight. Ah, shit.
You wouldn't have been fighting in that one. Lean forward.
I didn't fight nothing.
Lean forward. Lean forward. Keep going. Look, I'm going to loosen this one. I'm going to put 2 on you. But you better not move.
Cool. I'm not going.
It ain't. Don't move.
I'm not going.
All right, lean up.
Man.
Lean up.
So is that
Lean
polite?
up. Keep your hand right there.
Polite of the officers?
All right, keep your hand right there. That's all I'm saying.
The hell?
I want you to think about that.
2 o'clock in the morning.
We're going to bring you back to the residency. 2 o'clock in the morning, you're out here running.
Running from where? What I'm running for?
Stop, dude. Stop. You're really being childish, man.
Hold on, you got this in my back pocket. Hold on, what's this?
Yeah.
What you got, sir?
Let me lock him, so.
You never look. Bro, I just came from a fucking trail ride, bro.
I'm sure you did. So where's your car at?
I just told you my people never just dropped me off.
Dropped off in the woods?
No, I just got dropped off in the corner. You ain't
First
seen
of
the
all,
car?
stop yelling.
Yes, sir.
Okay? Because ain't none of us here.
Yes, sir.
We not yelling at you.
So Paul David asked, should they have given him a reason for why they're detaining or arresting him? I mean, it's nice for them to do so. I don't know if there's policy that requires it, but from my perspective, I'm always asking, is the issue constitutional? There's no constitutional requirement for them to disclose why they're doing it, as long as they can justify it. So do they have to give you a reason? No. Does it help with compliance, de-escalation, and all these other things that are consistent with their policy? Yeah, they should. And if they want to treat you like a human being, should they? Yeah, but does the law from a constitutional issue require them to? No, not really. So if you're right, what's the standard? It's probable cause to arrest you or reasonable suspicion to detain you. And part of that analysis is not whether they're telling you that, right? So I think they should, right? But from a constitutional standpoint, not really required. So you all saw the arrest. So I'm going to go back to the oral argument now because the courts, right? I listened very briefly, but I did pick up that they're talking about the arrest. So I'm just curious. Actually, before I play it, for those of you who saw it, again, we've seen arrests. Let's assume there was a lawful reason. I think, if I recall correctly, this specific guy was arrested for theft of vehicle. I'm sure we'll figure it out. But put that reason aside. This is a Fifth Circuit case. Put that reason aside. Do you see any reasons, any issues with the arrest? Again, I believe the issue was his shoulder was dislocated. I don't know if it's already happened. I don't know if it happens later. But the court is going to look at, you know what? I'm just going to play it. And then we could talk about it after.
We've asked that they be held accountable. With that being said, we do not seek to undermine qualified immunity. The issue I'd like to discuss during my time with the court.
All right. I don't criticize plaintiffs' counsel because it's hard to find them, but we should always be undermining qualified immunity. So don't say you're not, right? And if you've seen my interview with Professor Reiner, you understand that qualified immunity probably should not exist anyway. So we should always be undermining it.
Is what pleading standard a plaintiff should be required to meet to overcome a 12B6
Yeah, you can
motion.
sue for unlawful detainment if it's
you
unlawful.
mentioned in your opening the excessive force claim, but your brief talks about a delayed medical care claim as well.
It does, yes, Judge.
So let me ask you about that, and I know I'll give you, of course, you'll have time to talk about the excessive force claim. As I read your First Amendment complaint, I don't see a claim made for delayed medical care.
So how's the audio? I'm really doing this as like a test
was there
live stream too. So
nature,
let me know.
Which seems distinct from an excessive
If you have any
force claim.
questions,
Yes, Judge.
ask
to,
away.
to the extent that I didn't do a good job explaining.
Well, I'm not saying that. I'm just saying I don't see the claim made.
Sure. We meant to. And so I think the facts in the complaint establish that we were talking about a delay in medical care. We mentioned several parts of the complaint that they'd taken Mr. Hayes to the jail, even though he was making complaints about how his shoulder had come out of the socket. And they delayed it, and they made fun of him. In the video evidence, you can see that they're making fun of him in the jail and poking fun at him and saying things like that he's faking it, That is something that we talked about in that complaint, Your Honor.
Well, I've read the complaint. Let me ask you this. When the parties were arguing about the motions to dismiss, I looked at your opposition. I think you have multiple oppositions to the motions to dismiss. Were you arguing about the dismissal of a failure, a delayed medical claim? Because I just don't see it, but maybe you can point out to me where in your opposition. In other words, it seems like the parties were talking about excessive force and Monell and that sort of thing. I just didn't see a discussion of a delayed medical claim.
I to the extent that we tried to put the facts in there, Judge, I didn't make a separate claim section in the amended complaint.
Okay, so this is something else, and I will be talking about this in the main live as I go through James Springer's complaint, is whether you want to always review the complaint, right? Whether you're represented by counsel or you do a pro se. Even if represented by counsel, make sure you see the complaint before it's filed. And in this instance, if there's a medical issue, it sounds like the court's criticizing the lack of a specifically identified complaint or claim for medical. You want to make sure all of your claims, like it's very obvious to the reader that you're making a specific allegation, right? Delay medical, I hardly use because you need to show deliberate indifference, and the court has set a really high bar. So for this case, does it really matter? No, but it's interesting the court's kind of trying to divert away from excessive force and focus on a claim that apparently wasn't actually alleged that has a really high bar already. So, Jimmy, I think it's I have not seen the complaints. It sounds like, so given that they said, so it would probably be a 42 USC 1983, not necessarily a Monell, but maybe against the actual officers, because delay of medical is a constitutional claim. And this is in Houston, and Texas would not support a delay in medical care claim as a tort under state law. So this is going to be a federal constitutional claim. But it sounds like he didn't assert it. I don't know why the court's diverting there, but I don't know. Felt like it was a good talking point.
I'm not talking about the complaint. I'm talking about when you're arguing in front of the judge or in pleadings in front of the judge, you shouldn't dismiss the excessive force claim. I see a lot of discussion about excessive force and Graham and those sorts of things.
What's the difference between detained and arrested? Great question. What I've seen, putting people in handcuffs is an arrest and not detained legally. What's your take on that? So so there are three types of encounters, I would say, in the law, right? You have consensual, where it's just an officer coming up, talking to you, and then there's an investigatory stop, a Terry stop, and then you would have the actual, which is where you would be detained, and then you have the actual arrest as well. And there's obviously a fine line between arrest and investigatory stop, especially when you're talking about the use of handcuffs. And so courts generally look at a number of factors before they elevate right? Here's the key thing. If you were to bring a claim, I always keep it broad myself to unlawful seizure under the Fourth Amendment. I don't specify arrest or seizure unless I know for a fact my client was arrested, right? If they were actually booked, charged, etc. Otherwise, if I don't know that, or I think there's kind of a gray area, I'll assert a Fourth Amendment claim and I'll say, well, if this stop was a investigatory stop, they lacked reasonable suspicion for X, Y, and Z. If this was a arrest, they lacked probable cause for the same reasons. And that way I encompass both. And then separate from that, time and removal. Like if you're just putting handcuffs and you're left in the area, courts generally consider time. Like there was a case, I want to say it was Freeman versus Gore in the Fifth Circuit. Don't quote me on that because it's not in front of me. But I think in that instance, it was mother who was objecting to the police going to enter into her home without a warrant. They put her in handcuffs and then they dragged her to the vehicle and they left her in the back of the vehicle. I want to say for half an hour, if I got the case right. And the court concluded that amounted to a arrest because she was removed from her doorway, placed in a controlled environment, right in the back of a police vehicle for 30 minutes, handcuffed, to where you can't say that's a temporary detention. And all the factors that the court considered, the totality of circumstances, was that it constituted an arrest. But again, the way to get around that is you just plead unlawful seizure and you attack every type of seizure, period. But yes, officers can detain you by putting you in handcuffs, right, for safety or whatever hell they want. They're given a lot of discretion for it. And just by being handcuffed, it doesn't mean that you're under arrest. But that also means that they can't, what's a detention? You are not free to leave. If they're telling you are not free to leave, and they don't have reasonable suspicion to do so or some other authority to do so, even if you're not placed in handcuffs, they're still violating the Fourth Amendment. So it works both ways. Good question, though.
But I just didn't see any discussion of a delayed medical claim, which again seems distinct to me. So was that just not briefed below?
Yes, I think that's fair to say that we didn't brief it, and to the extent that I didn't do that appropriately, that is my fault.
Well, I'm not trying to assess blame. I'm just trying to figure out what was argued below, because it's just so to assess what we need to decide here.
I think in our brief to this court, the original brief that we filed, Your Honor, we mentioned that we did file a claim under the Due Process Clause of the 14th Amendment.
I saw that.
Which I believe encapsulates a delay in medical care.
Okay. Well, I mean, in theory, it could. It just doesn't say that.
Yes.
So, assuming you did make that claim and your client, Hayes, was taken directly to the booking rather than to the medical center, as I understand it, and then another officer who is not on appeal took him to the medical center. What was the lapse of time between when he got to the booking center and when he
Judge probably didn't watch
the
medical body
center?
camera.
Don't
Otherwise, he would have known that.
anything other than what you either say in your pleading, in your complaint.
So this judge already has a problem with this guy. You already know he's against you.
I don't think that we specifically identified how long the delay in time was, Your Honor, in the complaint. I do think based upon the videos, there is some time that lapses. In several of the videos, you'll see the police officers stop at a gas station along the way to the Joint Processing Center.
Secret courtship. Do you have a link?
The amount of time.
Check it out.
I'd be happy to
check it out. I'm only doing this until 6, and then I'm going to hop over to the other stream for the McKinney deal. So I don't know if you're looking at me doing it live or on my own time. But
of the injury during that time?
Your Honor, as we
email me a link.
Delineated in the complaint, and I believe in some of our briefing about the 12B6 motion, we did put an X-ray in the evidence of, as you can see, the shoulder joint or the ball of the humerus bone is actually outside of the joint. Mm-hmm. And so I think the evidence is there that, as well, Your Honor, we talked about Mr. Hayes over the course of a year afterwards was constantly having the shoulder joint coming out of place. And so they did put it back into place, but because of the force that was used to pull it out of place, he continued to have problems with that shoulder joint. When he would just be doing normal daily activities, the shoulder would come out of place.
Going back to Judge Duncan's original question, can you point me...
Judge Duncan, I think it's a Trump appointee.
In your complaint that you contend adequately plead deliberate indifference?
I believe that there's a claim/cause of action at the end of the complaint where we talk about the violations of due process.
Comment is very true. Very
and
true.
I think that a delay in medical care claim would be encapsulated in that, Your Honor.
Let me help you out a little bit with that, because I think what Judge Willett may be referring to are factual allegations, not legal allegations.
Texas
So in
Supreme
paragraph
Court
35,
justice, also a Trump appointee. So there's two Trump
well, in paragraph
appointees on this
33, you
bench.
said they did nothing of the sort, meaning take him to get medical care. Instead, took him to the Joint Processing Center. And then in paragraph 35, and this is my question, I promise, last question on this, so you can get to excessive force. Once the officers took plaintiff to the Harris County Joint Processing Center and the handcuffs were taken off,
How do you know they're fake
plaintiff
pineapples?
started to notice the extreme nature of the injuries that these officers had inflicted on him. He noticed that his right shoulder just dropped and was in excruciating pain. So is it a fair inference from that he realized what had happened at the Joint Processing Center?
Yes, that is fair, yes.
Okay, so the nature of the delay claim is not from the...
Okay, so that's interesting. So this guy put in his complaint. I got to go probably pull the complaint now. But if you caught that, he put in his complaint that the guy didn't realize his shoulder was messed up at the time of the arrest, but apparently it was at the Joint Processing Center. I think I could see why the judges are going to side against that, right? Because if there's an instance that happened exactly at that moment and you knew, right, because of the pain, I think that would be a pretty big issue. Yeah, medical is overlooked a lot. That's because there's a deliberate indifference requirement, right? Which is a higher threshold than just simple negligence. Like you could just be negligent and just not do it, but that's not enough. You have to show that they deliberately knew that they had knowledge of your issue and they blatantly disregarded it. That's what, and you have to prove that. They could say, "Oh, I had no idea." And then you have to prove that they did have an idea and they just screwed up. So
arrest, but from his arrival at the Joint Processing Center. Okay.
Yes, Your Honor, that is correct.
Now, you cited us to, you just spoke about an x-ray, and I'm not aware that an x-ray was attached to your complaint.
It is actually embedded in the text, Your Honor.
The x-ray is embedded in the text?
Yes, it's in the middle of the page in the complaint. And it's also in our brief, and I can find the page in our brief as well.
All right.
I don't remember what page it is.
Look,
but
I've got the complaint right here. It's on ROA 145. About the force, and then there's video. So I've looked at the video, as we always do. To my eyes, I can see everything that happened during this arrest, from the moment of encounter, even before the encounter, to the interactions, to the handcuffing and everything. So,
okay. You all have seen the arrest, right? You watched the arrest. And if you notice, what the judge is doing is he's pointing out, hey, you brought these excessive force claims, but at the same time, we saw the video. That's what he said. We saw the video. Anytime a judge says that, like, hey, I know you brought these allegations, but we saw the video, it's not going to go well. So, do you all have any opinions or anything based on what you saw on the arrest? It looked like there was an excessive force issue. And you can assume the cops are dirtbags, right? But just based on what you saw in the video, objectively speaking, put your feelings aside, just objectively speaking, dirtbag cops, right? You can believe that. You have a right to believe that. Did you see excessive force with the arrest? Yeah, muting body-worn cameras should be definitely outlawed. I agree. 1,000%. Okay. Was late to the stream. Okay. Yeah, no, that's fine. So I'm just going to play. We'll listen to what the judge says.
So react to this. And I'm certainly not doubting the injury. What I see in this interaction is a fairly standard arrest where, there's some going back and forth between the officers, there's some yelling, there's a handcuff, and then I do hear the complaint, my arm, and then the officers take him out of the car and give him additional handcuffs so that his arms are not so close together. So, do you disagree that that's what I'm going to go on when I'm thinking about an excessive force allegation? Because
there's two things you have to watch out for anytime you have a case on appeal and you're going to oral argument, whether pro se or if you're an attorney or whoever's watching this, is first, the video is always going to control if it shows the circumstances. By law, the courts are going to say it doesn't matter. There's always a he said and a she said, and we're going to follow the video, and they're going to ignore everything else. That's just the reality of it. The way you get around that, if the video is not favorable, is if you can establish that there's things or events that occurred outside of the video. Either they didn't activate their body-worn camera, either they muted it, either the body-worn camera didn't show everything, or they shut it off early. So when you can establish that there's events that occur outside of the body or out of the video, you're good. Now, what the judge here is setting up on that question is he's like, hey, you'd agree with me. I saw the whole interaction. I saw when they walked up to him, there was yelling, a little bit of, yelling back and forth, and they put him in handcuffs. They took him out and they put 2 handcuffs on him. What he's trying to do is set him up to acknowledge and agree that there's no issues that occurred outside the video, right? That's why he's doing that. The second thing is, if a judge is asking you something that's not in your brief, they will use that against you, right? If they say, will you concede on this point? Well, the answer there is, I'm not going to concede. I am relying on my brief. Because if you say something during oral argument that you concede on, there's a reason they want you to concede on it. That's because they're going to use that, in their opinion, to probably rule against you. So never concede, stick to your brief. That's all I'll say on that.
Because I can see it with my own eyes.
Yeah, and I don't disagree, Judge.
Okay.
And I think it is at that moment
He just
in time
conceded.
when they're bending him over
Yeah.
and they're pulling his arms backwards, upwards. You can see the officer start pulling on his right arm, and he pulls upwards.
They're doing that to satisfy his request that they loosen the handcuffs. They said, here, bend over so we can get this, so we can double handcuff you so you're not going to have this problem.
Yes, Judge, but
And he doesn't say a word when they bend him over. Ask him to bend over.
All right. Would it be helpful if we went back and watched the actual arrest? All right. Let me see.
People, that's why you call it. Let go your phone, man.
Hold up, man, my arm, bro. What is going on, man?
You already know
Twist your
what's
wrist,
I don't know
bro.
what's going on, bro.
Twist your wrist.
Look, if I'm boss man, you gonna hurt my arm, bro.
You the one fighting it, dude.
I ain't doing nothing.
Where you going? You got anything on you,
Nah,
bro?
I ain't got shit on me, bro. The fuck?
Why are your pants all wet?
Man, I just came from a trail ride.
Oh, stop.
Look, I just came from a trail ride.
Where's your car?
My people in them just dropped me off. My people in them just dropped me off, man.
Where's your ID at?
In my pocket, my right pocket.
Okay, why are you
Do you
yelling?
put
Well, so I'm trying to
you
see
put
what's
him on
going
upside down? I have to
Y'all up on me like that.
look at that.
I don't know what's going on.
Get in here.
The fuck? Hold up, my arm, bro. Hold up, my arm. My arm. Hold up, my arm.
Get
I'm
in
not
there.
going to boss man. My arm, I'm telling you.
What do you
my
want me to
arm.
do?
You got him too tight. Unloosen a little bit. I'm not
I
going
got him
nowhere.
too tight.
I'm not running nowhere, bro. Unloosen a little bit of something. That
Well, if you
motherfucker
wouldn't
too
have fought
tight.
it, so
That motherfucker too tight. Hold on a second. Ah, shit.
you wouldn't have been fighting it. That wouldn't happen.
Lean forward.
Fight nothing.
Lean forward.
Ah,
Lean
shit.
forward. Keep going.
Oh, good catch. He did put them on upside down. Do they teach that at the academy?
Look, I'm gonna.
So, what the argument from plaintiff's counsel was at oral argument is when they bent him down to do this, they indicated that the officer lifted up on his arms, and that's probably what caused the dislocation.
Listen to this one. I'm gonna put 2 on you. But you better not move.
Cool. I'm not going.
It ain't. Don't move.
Man, I'm not going.
All right,
nowhere,
lean up.
man.
Lean up. Lean up. Keep your hand right there.
I'm not going nowhere.
All right, keep your hand right there. That's all I'm saying.
The hell?
So one of the judges also pointed out at this point, right? If the dislocation did occur there, he didn't say anything about it, right? So the court kind of criticized him a little bit for that.
Two o'clock in the morning.
We're gonna bring you back to the residency.
2 o'clock in the morning, you're out here running.
Running from where? What I'm running for?
Stop, dude. Stop. You're really being childish, man.
Hold on, you got this in my back pocket. Hold
All right.
Yes, Judge, and I think we talked about that in the complaint. A person who goes through something like that, they're being arrested, there's a lot of adrenaline that's going on, and he didn't realize that the injury was so severe until they got to the Joint Processing Center. And so at that moment, you'll see the officer raising the shoulder joint to a point that it shouldn't be going to. And it is at that point when...
doesn't show that.
I respectfully disagree, Your Honor.
He doesn't say a word when they put him in the car, like, boy, you've hurt my shoulder. He doesn't say a word. They just put him in the car. They were very, very courteous to him. I was struck by how courteous they were.
I guess just following up on that, I'm not doubting the injury, but when I look at we have so many of these cases where there's sort of a scuffle or a takedown. There's some resistance, and then the takedown, and the allegation is, well, you used too much force in taking me down or in catching me. And this one, it seems a little bit odd in how not and just sort of how normal it is. It's like, well, okay, the guy obviously didn't like being arrested.
Yeah, I think adrenaline's
what is the nature of the
pretty reasonable response
allegation here? Again, I'm not doubting the shoulder dislocation. I'm just what is it that I'll always ask myself, well, okay.
And the reason they can't, if you missed it, the reason they can't doubt the shoulder dislocation, there's two reasons why. This particular lawsuit was a 12B6 motion, which is at the very beginning. It's right when you have your complaint, you file it, you serve the defendants immediately move to dismiss. But it sounds like in this particular case, I was kind of looking over the docket sheet, that in the motion to dismiss, the defendants attached the video. And when they do that, if the plaintiff doesn't move to object to the addition of information outside the complaint, then it's converted into a summary judgment. And then it puts more obligation on the plaintiff to file a motion to either not consider the information or allow opportunity for discovery. I think they try to get some discovery here, by the way. And at the end of the day, though, the court always has to construe facts in favor if it's not right, unless the video shows otherwise. And if there's a dispute, the courts have to construe facts in favor of the non-movement, who would be here, the plaintiff. So the first reason they would have to, they can't discount the dislocation is because there's nothing to disprove it, right? And so they have to construe that. The second reason is because apparently there was a photo of the X-ray actually attached in the pleadings. So, yeah, HBO Matt, for saying, okay. Yeah. If she emailed me, I'm sure my team will get that to me. just make sure, yeah. If not, just reach out and let me know. Okay. Send me a name, HBO. Send me a name. I guess you can do it through Portal. Send me a name so I can kind of filter it out. Okay. So, man, delete laws be deleting chats. Let me see. All right. So the court's obviously going to say, I'm not going to discredit this. Well, no, that's because you can't, right? So let's see where else they're going with this.
In this situation, what did the officers do that they should not have done?
I think, and we quoted this in our brief, Your Honor, is the Aguirre case where it talks about how, and additionally the Bartlett case, how force should be proportional. And so,
well, sure, but those kids, I'll just tell you right now, I'm very familiar with both of those cases. The Bartlett is just an savage beating of someone who's not resisting, and the Aguirre case is leaving somebody in a maximal restraint position for so long that he suffocates. Right, so that just seems different from this case.
The part that I think kind of shines light on all of this is the conversations by the officers later on in the videos when they're at the hospital. Okay. If Your Honor would turn, there's a video number 25. We cited it in the brief. Okay.
I didn't see that video.
25, the timestamps are 23 minutes to 24 minutes.
So there's a hospital video. I was not able to get that one.
You hear the officers talking about what they think
Not
happened.
Yet. I'll go see if I can.
While they're talking about it, they discuss that, I think I did it when I put him in the car and I did that maneuver. And so I think that kind of shines light on it. They also
talk kind of admitting that maybe they did it
force.
When they added the two cuffs.
You can clearly hear that being uttered on the video evidence that's before the court.
Okay.
So keep in mind the standard for any of this stuff is, quote, reasonable, right? So if stuff is to be reasonable or beyond debate. So if cops are kind of second guessing, like, well, when I put the cuffs on him, did I do this, right? Courts are always going to give deference to the officers. So.
What is your best response to the argument that officers are certainly entitled to maintain control of your client's arms while they're adjusting the handcuffs? You don't dispute that, right?
No, Judge. I think the problem is the maneuver that they did, and you can stand up and have someone pull the handcuffs off and do double cuffs. You don't need to be bent over into the car.
And where is that in the complaint or in any evidence the district judge viewed?
That would be in video 1, Your Honor.
You're giving us your view of what. If you do this, you don't do that. You need to stick to what's either in your complaint or in the videos, and I think that's
second or third lecture this judge has given this guy. You know, when that happens, it's not going well for you.
Now you're giving us your opinion on what causes harm.
At that point, you just go balls to the wall. If you know you're going to lose, you just
about this maneuver, Judge, and we talked about, and I think I
do what you can.
Reference didn't make sense, but we talked about how it was like a jockey holding reins.
Nope, you're right, Space Miner. Not go well at all.
And so I think that is discussed in our complaint, Judge.
But you're telling us about you don't need to go to that extreme, et cetera. Just stick to the evidence. This is summary judgment.
Fourth.
That's something I would like to discuss with the court, Judge. I think. Oh, I'm sorry, Judge.
All right. Let's just following up on that. Let's assume, for purpose of argument, that there is a violation here.
No, this is a plaintiff's lawyer.
Excessive force was used.
It was the cop's lawyer. They'd probably be going a lot nicer.
Established law, though, that would put these officers on notice that doing that, sort of this maneuver here to lengthen the handcuffs, that's clearly established.
You know, Jimmy, you could be right, but I don't like criticizing attorneys that do the bold thing and take these cases. What I would prefer is even if they take the cases, they reach out for help to other civil rights attorneys. That way they're putting on the best possible fight. But the problem is you do get a lot of civil rights attorneys who just get, or attorneys that tried and they get just chewed up and spit out. Like, a lot of people think that civil rights attorneys do this for the money. Those are people that don't understand that these cases, you might win 3 for every 10, right? It's not an easy fight. It would be a lot easier if I just went and took like semi-truck cases, for example, or insurance cases. But that stuff doesn't change the law. It doesn't, I've always fought and defended the Constitution, and it's always been part of my moral code, and I intend to always do it. I didn't become a lawyer to make money and do these, do the easy way out. The unfortunate thing is I'm put in a position where I have to take cases where I know it's going to be an uphill battle. And, we all have to start somewhere. But don't think that these attorneys are doing it for the money. There are attorneys out there that make, good money, but it's few and far between. And most attorneys get they get discouraged, right? Because of they can't overcome qualified immunity, and they just keep getting beat up. There are some weeks, even me, there are some weeks when I will just qualified immunity wall hits me over and over and over and over again. But the reality is, if we just get one to break through and we crack that wall, to me, it's completely worth it. It's not about the money. Obviously, I have to, I got bills, I have staff, I have all that it is important. But keep in mind that if somebody says they're a civil rights attorney, it's not about the money, because if it was about the money, they would do a lot better with significantly less work doing personal injury. I'll just say that. Nothing against personal injury lawyers, but I think if they really wanted to work and see what work was like, take a civil rights case. And then they may only take one and they'll never touch it again, right? That's the problem. So if someone's bold enough to take a case, right? And I'm sure you all complained about that. You are like, hey, it's so hard to find lawyers to take these cases. Well, that's why. Because they don't like losing. They don't like putting time and effort and work only to lose. They don't like the double standard. They don't like that government officials get treated on a much different level, right, than anyone else in the entire world. So that's why I would, I'll just keep playing this. Thanks for listening.
Established law, that's a violation. What's your best case or cases for that proposition?
The first thing, Judge, is that I think that the Santander decision kind of should make this process a little bit easier for plaintiffs. And so the Santander...
Well, I mean, I hear what you're saying. I've read your brief, and I know you're running out of time, but we routinely ask for a case or cases that would have put officers on notice that, nope, don't do that, right?
So I'm sure you all know what this is, right? It's the clearly established standard, right? They're the 2 prongs. And courts always start with the second one. Is it clearly established? First prong, is there a constitutional violation? Second prong, can you point to a case or law that would have put every officer on notice that the issue is beyond debate? So that's what the court's asking. Do you have a case that says if you were to bend a suspect over to add a second set of cuffs, that you can't do that because it would cause injury, or you have to do it in such a way to not cause injury? There's not a case out there that says that. Right? So if you don't have that, especially in the Fifth Circuit, you're losing. You're losing.
What are those cases that I should look at?
Go ahead.
May I answer?
Yeah.
I think the cases that we've cited in our brief, Judge, there's Aguirre, there's I think the proposition of law is that it has long been clearly established that when a suspect is not resisting, it is unreasonable for an officer to apply unnecessary injurious force against a restrained individual, even if the person had previously not followed commands. It is clearly established that exerting significant continued force on a person's back while that person is in a face-down prone position after being subdued and or incapacitated constitutes excessive force.
So he found a case, it sounds like, and this is my issue, that, again, we already know what the court does, right? I don't know what they're going to do in oral argument, but I know from their written opinion, their one paragraph, that the guy loses, plaintiff loses. So he found a case, and this is where a judge's subjectivity comes into the picture. If the standard is I need to find a case that puts everyone on notice, and then I go and I find a case or 2 or 3 cases that puts an officer on notice, in my opinion, the judge gets to pick and choose how closely related my cases are to my client's situation. If they like my client, if they like me, if they like, the case or whatever, they're gonna find a lot of comparisons. But if they're pro-cop, pro-qualified immunity, and they don't want to deal with it and they just want the case gone, they're going to find every way to distinguish the case as possible. So this is a situation where you're going to have courts, you could have 10 different judges reach potentially 10 different results in how they review the case as to whether it's clearly established. And unfortunately, in those circumstances, if they would there's people that would argue, well, if you have judges reach in different circumstances, well, then obviously it can't be clearly established, right? And the reason I bring that up is because the idea is they say you don't need to have a case exactly on point, but the problem is courts, if they want to, are essentially looking for a case that's exactly on point, right? And so I expect that's what's going to happen here. They're going to tell him why the case he picked and he just talked about is dog shit and doesn't apply here.
I think that it is clearly established in this district, at least since 2014 or 2013, Judge, that after a person is restrained, a police officer shouldn't do, should not be using any force at all, because that would be excessive, and that's the clearly established prong. Thank you.
Thank you very much. We'll see you back on rebuttal. Ms. Petty, welcome. Good morning.
Thank you, Your Honor. May it please the court. Let me start with the delayed medical care claim, because there really isn't one here.
So court didn't really attack his
cases.
cases.
Among his 14th Amendment claims, he specifically lists them in the complaint.
So the government's lawyer is she's doing the right thing. I mean, it's garbage, but she's doing the right thing as an advocate. She realized that the court spent a lot of time on, hey, you didn't bring up this medical thing. Why not? Like, it wasn't briefed, wasn't in the complaint. They derailed the guy's argument. And so she's getting up there to the podium and she's going to say, hey, I just want to re-bring up this failure to plead stuff, right? And you're obviously concerned about it. I want to be concerned about it. Has nothing to do with the case. But she's doing it because she knows that's how she's going to get a further or deeper alliance with the bench.
Delayed medical care is not one. Instead, he's rolled it into the excessive force claim. In fact, at page 49 of his brief, where he sort of isolates the paragraph in his complaint that he thinks satisfies Santander and all of the relevant standards, he talks about not taking him to the emergency room. So there was no separate claim. The court did, however, address medical treatment in its discussion of violation of Houston policies.
Is it disputed or undisputed that the officers delayed medical attention for hours after observing the injury? What do the facts show?
The facts in the video, I think, are unambiguous. They are, and I think Judge Barksdale and Judge Duncan have pointed to them in a very important way. What the video shows that before or as the cuffs were being put on the first time, he said, hey bro, my arm. Mm-hmm. At that point, the cuffs were put on. He didn't say, I'm injured, I need to go to the hospital. At that point, nothing more was said until he said, my arm, and that's when he asked to have the cuffs loosened. They were loosened. After that, Judge Barksdale's absolutely correct, he didn't say a word. Instead, when he got to intake, he said, you know, I didn't really realize it, but now the cuffs are off, my arm's hanging, I think I'm injured. At that point, it appears that he was taken to the on-site medical team to assess him and then was sent. Your Honor, I don't know, because that's not been an issue that he raised. I would say that the entire discussion of delayed medical treatment here and what he says in his briefing is that the officer should have known he was injured from the time they put him in the handcuffs or shortly thereafter, and they should have taken him to the ER then. He does not make any allegation of delayed medical treatment after he got to intake, and I think that's very important here.
The court dismissed the medical care claim as simply unpleaded.
Correct.
I just wonder if the complaint were maybe cursory and artful, however you want to characterize it, even if the complaint were all that, why wouldn't the factual allegations at least trigger an obligation to analyze?
Does that answer your question?
Indifference as opposed to dismissing it outright.
Again, Your Honor, Houston would be entitled to some notice of what the claim is. For example, now there's discussion of was it delay after he reached intake? That was never part of the case. So
that's the key thing. Obviously, there's a lot going on in the circumstance, but Venom, you stated a good point. You do need to, like, the first hurdle you have to overcome on these things is knowledge, right? That the officers had knowledge of the medical emergency. So you need to ask for it, right? That gets you over that first hurdle. The problem here, it sounds like, is he never asked for it and didn't even realize that was an issue until he arrived at the jail, right? But then at the jail, they got nurses or whatever, who knows? But kind of lets the cops off the hook.
The only thing that one can glean from the facts is the initial arrest to intake. And at that point, you had the video that very clearly showed that he didn't say word one about his injuries. And so it would require that the officers be effectively clairvoyant, that they know he was injured before the plaintiff himself knew it was injured. So that's, I think that's the basis on which the court could dismiss as opposed to engage in some sort of analysis. Because otherwise, you're really putting a burden on the police that they really can't sustain.
You're in the care, custody, and control of the police. You should put the burden on them.
Discussion of a delayed medical care claim?
No.
I went looking for it because I thought, well, there's not much here, so let me go see what they said below about it, and I don't see anything.
There's absolutely nothing.
I don't have that video, Jimmy.
It is
I didn't get that
basically
video.
that the officer should have taken him, or should have called an ambulance at the scene, frankly, and had him taken to the hospital at that point. But there's no suggestion of delay.
Maybe I do have it.
It's
I
more
honestly,
of a
I
suggestion
didn't.
of deprivation.
Let me look. Let's just ignore this. Let's go back to the body worn camera. See what we got here.
What's this?
Yeah.
Just call him.
That's clear, man. No, man. You need some air?
Yeah, I can't. I'm trying to see what's going on.
Why you guys see what's going on?
What you mean? Y'all got me on the scene and I don't know nothing about it.
All right. Hurt.
Your phone hasn't rang once.
Just listen to what I said.
I'm listening to what you're saying.
All right. That's
I mean,
look it up,
bro. That's fresh.
I think so.
I know where Crosby is, bro. That ain't no way that didn't dry up between there and Crosby. I'm listening.
The trail ride is still going on right now, man.
Did you not just listen to what I said?
I'm listening to what you're saying.
All right.
You're saying a murder suspect, a murder? I ain't got.
I never said nothing about that.
Yeah, that was me. You're not a murder suspect.
Yeah, I just ran him. Okay. Here's his ID.
Fuck a murder.
He has a PCS charge, assault.
I'm on probation right now.
All right, cool.
Well, you in violation of your probation.
How?
committing a crime. Can't commit any crimes on your probation. Are you gonna Miranda and ask? Yeah.
Well, hopefully wants the first charge.
Yeah.
See if the DA takes it.
Literally the road just north of this.
Four copy? I think.
No. Dead.
You know, by a judge for doing a slip, but no.
On his bits.
Yeah, it was control right.
They were fixing to unload the trailer. He said whoever suspect was hopped in, took off with the trailer and the truck.
Want to pick it up?
No, it's like
It's
2 hours.
yeah, it's far.
Maybe more.
So he wants to press charges. He said it's about 30 grand in value on the truck. And he said that he want to press charges for the trailer, the cows, and everything.
Well, we don't have those.
We don't know this stuff, yeah.
He's definitely
Ye-
daring
ye.
to label.
Huh?
He's definitely daring to label.
Yeah.
What he's saying.
That's all they do.
Oh, yeah.
It's
And he's in the area, yeah.
Yeah, he was leaving that up.
So it sounds
Did you
like that.
already-
Yeah.
He's in there.
They-
Right here, yeah. Go the other side, passenger side.
He was saying what?
Yeah, at first
He got dropped off. He just got dropped off over there in the abandoned parking lot.
Okay.
And then he had his boys to come pick him up, but his boys drove past
New
us.
Cadillac.
Did they say anything when they passed by?
No, they
didn't
just slow
stop.
rolled.
They slow rolled, seen it was him, and they were gone.
Oh, that's it. They pulled up
What?
You what?
Yeah, they are kind of just a lot of speculation, right?
Up over here. Haynes. I'm sorry. Kind of upset. Man, it took Doss asking you for me. Hey,
All right. They got. Oh no, I thought that was medical, but maybe not.
we can't do that, bro.
Police is out here, man.
I understand that, but we can't let you.
Piss on myself?
We can't let you just go
Sarge.
anywhere.
What? Ain't nobody told me what's going on. I need to take a piss, man. I'm not going nowhere at all. I promise you I'm not going nowhere.
It's fine.
I just need to know what's going on, and I need to take a piss.
Okay, right now you've been detained right now because that truck right there that you're driving is stolen.
Okay, that wasn't my truck.
Whose truck is it?
I don't know who truck that is. I don't want to know what. They brought me over here. I was going to my girlfriend's house. They brought me over here. He told me it was a murder scene. I'm like, a murder? What's going on?
So where were you coming from?
I just left Crosby, Texas, sir, buried. It was a trail ride out there.
Okay.
Real deal trail ride. I just left from Real Deal trail ride.
And you were walking to see your girlfriend?
No, my friends and them just dropped me off.
Where they dropped
I told
you
them
off
that over there on the corner over there.
They dropped you off over
On the other side, over there at the corner.
And what's your girlfriend's address?
I don't know her address. Oh, these fucking handcuffs, but I need to take a piss, man, before I piss on myself. But I was going to my girlfriend's house, man. Next thing I know, they pull up. I hear when they turn the corner, they turn the corner real fast. Then I see the lights. I turn around. I didn't try to take off running or anything. He asked me, this guy right here asked me to put my hands up. Threw my hands up. And that was it. They tell me that I was, they didn't tell me I was detained. He told me to put my hands behind my back. Okay. He asked me to put my hands behind my back. I put my hands behind my back. Okay. Didn't explain to me anything about what was going on, anything like that. Okay. So now you telling me, first he says murder. Now you telling me that the vehicle is stolen. How? You stole the vehicle, and I wasn't nowhere near here.
Okay. What were your friends doing that dropped you off?
I just told the man. I told him I'd give him my code right now on my phone. You can call him. The code on my phone is 11-2020.
11-20-20?
You can call him right now. I give y'all full access to get them go through my phone, man.
And what was your friend's name that dropped you off?
Bull.
Bull?
In my car, the vehicle. I told him right then and there when my friend was leave dropping me off. I told him that's my friend dropping me off right there. They let the vehicle go.
You told us your friend was picking you up, though, sir.
No, I just told boss man, how could he be picking me up if I told you I just got dropped off? I told you I had just got dropped off, boss man. But don't turn the camera off, turn the camera on.
I didn't touch the camera.
Oh, but that's what I'm saying. I told you that I was getting dropped off. And y'all let the black vehicle drive off. It was a black XTX. They let the vehicle drive right off. I need to take a piece. I'm not just running nowhere, man.
So this is what the court would probably say. Hey, he wasn't complaining about his shoulder.
He's saying now he was going to his girlfriend's house.
Oh, now he's changing his story. Okay.
He said that his friends just dropped him off. He was going to his girlfriend's house. But when we grabbed him, he said his friends dropped him off and they were coming to pick him up.
Yeah, he's definitely talking too
I
much.
don't know what that is. See what the map says it is. Stop lying.
Only thing you should be saying is lawyer. Lawyer, lawyer, lawyer. Silent. I want to remain silent. I want a lawyer.
They updated it and I don't know how to work it now.
And that's not legal advice. That's just common sense
And he
advice.
was out of breath whenever we...
Why do you need a unit for an unoccupied store?
Dropped off this.
You seen those occupied?
from us.
It's covered.
And his buddies were picking him up.
Which he was on the phone with them and they swung by, but as soon as they slow rolled and as soon as they seen him, he was getting put in cuffs, they sped off.
Yeah. And then he just told you he was going to his
I
girlfriend.
don't know.
So he wouldn't tell us where it's slowed up as soon as we go. We got him in our back. Now we're going. Where am I?
And the primary...
Over the bridge.
He said like 1,200.
You get the truck.
In his pockets.
She got nothing in my pockets. There's nothing in my pockets, man.
Maybe that was just...
It's nothing in my...
It's a little weird. I'm pretty sure I've seen video from the Houston intake center, and I don't think it's under a bridge or highway. This looks, I mean, we're 37 minutes into the body camera. Why are they still at the scene? This is weird.
Y'all not, you ain't nobody told me anything what's going on though. You said a stolen vehicle. Sarge, I can't talk to Sarge real quick.
Yeah, he'll come talk to you.
Sarge, he told me right now. Okay. Sarge, what is going on?
You've been charged with the unauthorized use of a motor vehicle.
Sarge, how is that, Sarge?
You were driving a stolen truck.
Sarge, I've never seen that vehicle a day in my life.
That's fine. I understand, and here's the thing. That's what lawyers are for. That's what PC judges are for. This isn't court. This isn't a conviction. You've been alleged. There's probable cause for...
What was the probable cause, though? Ain't nobody told me what the probable cause was.
Probable cause was you were driving a stolen truck. You ran from the stolen truck. They caught you.
Boss man, no one, I didn't get out running from a vehicle.
Okay. Yeah, you're on the other side.
I was going to my girlfriend's house. He caught me. They stopped me and arrested me on the corner of the vehicle.
You've told me your case, and I understand that. And I've explained to you what you've been charged with and where you're going to jail for. Okay?
So I can't make a phone call or anything like that.
Not right now, no, sir.
You went down to jail. They'll get the phone.
No other complaints about shoulder. Not even there either. Okay.
All right, I'm gonna people have done that.
Okay, I'm gonna take a quick break and then I'm gonna switch over to the other live for the McKinney deal. That was the end of the body camera. There was only a couple of seconds left. I don't think we saw anything. So I appreciate you all joining on for this test stream, and I'll see you at the next one. All right, you have a good one.